Podium mic check 1 2 3. Podium mic check 1 2 3. Wireless speaker lav check 1 2. Wireless microphone check 1 2.
Good morning, everybody. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, April 26th, 2023. The time is 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith, and I'm John Neerman. For those who are joining us virtually, please keep your microphones muted when you're not speaking. For those making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item number that you'd like to comment on, and we will do our best to accommodate that request. And with that, I'd like to thank everybody for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the application by SWWC Utilities Incorporated for new TIPD's permit number WQ00160220001. The parties have been notified that the Commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, the first 5 items on our docket this morning are hearing requests on TIPD's permits. So the same rules and analysis will pertain to our effectiveness determinations. Chapter 55 of our rules, as you know, provides a 2-part analysis. First, we consider whether the requesters have met both the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has done so, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Associations can have standing if, among other factors, they identify a member who would have standing in their own right. And on this first item, item 1, colleagues, we have 4 requests. This is on the application by SWWC Utilities. 3 of those requests are by individuals and 1 from an association. All 3 of the individuals are identified as members of the association. And on this one, I agree with the Executive Director and the Office of Public Interest Counsel that none of the requests have adequately demonstrated effectiveness. At 800,000 gallons per day, this is a relatively moderate discharge rate, and none of the requesters own property within 2.5 miles of the discharge point. And I do want to emphasize that proximity is a factor. You know, we know it to be an important factor, but it is not dispositive. Cases with different facts could indicate effectiveness even at distances greater than 3 miles. For example, the City of Liberty Hill application sought authorization for 4 million gallons per day of discharge. That's 5 times what SWWC proposes. That case also featured evidence of actual impacts and a history of significant noncompliance. So with that different set of facts, we reached a different result. And the point that I'm trying to make is that what we're doing here is we're weighing different factors, that there is no bright line test, including none pertaining to distance. So with that explanation out of the way, that's how I view this this particular item. Commissioner Lindley, what are your thoughts?
I'm in agreement. All I would add is, I believe for some of those in the Liberty Hill case that you brought up, for some of the ones that, I don't remember if it was further distance or why exactly off the top of my head, but we referred them for effectiveness. We didn't even,
Right.
Flat out give them party status.
Right.
So for the reasons you stated, I'm in agreement on denying those hearing requests.
Commissioner Janecka,
Well said. I'm also in agreement and nothing different to add.
I think we're ready for a motion.
Did you cover the association as well, or just individuals?
Well, the association bases its effectiveness
Okay.
demonstration on the individuals,
Yeah.
and without those individuals.
Yeah, and I should have clarified, I'll make a motion, it's gonna be deny all the hearing requests, so
Right.
that would cover all of them. So
Yeah.
with that, I would move that we deny all hearing requests, issue new Texas Pollutant Discharge Elimination System permit number WQ 00160220001 to SWWC Utilities Incorporated as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the application by Aqua Utilities Incorporated for new TIPD's permit number WQ0052060000. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, on this item, we have a single hearing request, and this one is from the applicant. And under 30 Texas Administrative Code, Section 55.201B3, applicants are entitled to a contested case, so we are not required to evaluate effectiveness. I don't see any significant disagreement about how the issues might be articulated. I'm just forecasting that. So if it's all right with you, what I thought I'd do is just go ahead and lay them out in a motion, and then we can discuss it on the other side. All right. Colleagues, I move that we grant the hearing request of the applicant, Aqua Utilities Incorporated, that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit's effluent limitations for total dissolved solids and sulfate meet the applicable criteria and methodology of 30 Texas Administrative Code, Chapter 307, and the procedures to implement the Texas Surface Water Quality Standards. Issue 2, whether the draft permit properly characterizes the presence of perennial pools in the receiving stream. And finally, issue 3, whether the geographic locations for water quality data in the receiving stream used to establish the draft permit's effluent limitations are accurate and consistent with applicable TCEQ rules and guidance. And I further move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued. And thoughts, discussion?
I would be in agreement, but I don't want to second it until I've given.
I had exactly the same thought. I don't have any disagreement. I think that's an appropriate framing of the issues to move forward. I think this initially appeared as a more peculiar item where there aren't multiple parties involved here, but I think it's appropriate for our process to be used here to serve the technical concerns raised that fall within our ambit.
Is
I
there a
would second the motion then.
Okay. The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by HK Real Estate Development LLC for new TIPD's permit number WQ0016150001. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have been signed in will be noted for the record.
So we again have a single hearing request on this item 3. This one is by Frazier LLC. And while the application is for a relatively small discharge, the discharge would run directly through the requester's property, which is within a half a mile from the facility in outfall. And because of that, and because Frazier LLC articulates personal concerns that are relevant and material to the application, I would grant its request. So let me pause there and see if you came out the same way.
Agreement.
Okay, I'm seeing agreement. Turning to the issues, I would refer the following: whether the draft permit is protective of water quality consistent with the Texas Surface Water Quality Standards, whether it is protective of Frazier's use and enjoyment of its property consistent with those same standards, whether it adequately addresses nuisance odors, whether the application adequately characterizes the discharge route, whether the facility is adequately protected from inundation, And finally, whether the applicant made a copy of the administratively complete application available to the public as required by our rules. And I realize I read through that list very quickly, so I apologize. Were you able to
I
keep
believe
track
so.
with that?
I believe I'm comfortable with it.
Likewise.
Okay, there's a request for reconsideration, which is probably obviated by the referral, but in any event, I would deny that, and I would allow 180 days for the hearing.
I agree.
Okay,
I think I'm prepared with a motion that captures all those points.
great.
I move that we grant the hearing request of Frazier LLC, deny all remaining hearing requests and request for reconsideration, refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is adequately protective of water quality, including the protection of surface water, groundwater, and animals in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the discharge route is adequately characterized in accordance with 30 Texas Administrative Code Section 309.12. C, whether the draft permit is protective of the requester's use and enjoyment of its property in accordance with the Texas Surface Water Quality Standards. D, whether the proposed facility, if it is located within a floodplain, is adequately protected from inundation as required by 30 Texas Administrative Code, Chapter 309. E, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13. And F, whether the applicant complied with the requirement to make a copy of the administratively complete application available for public viewing in the county in which the facility is located in accordance with 30 Texas Administrative Code, Section 39.405G. And finally, move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the application by the Vantage Austin LLC for new Texas pollutant discharge elimination system permit number WQ 00161-32001. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, once again, we have a two-part analysis for considering requests for contested case hearings on these TIPDs permits. Part 1 is about who gets a hearing. Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Governmental entities can demonstrate effectiveness if they also demonstrate statutory authority over or interest in issues relevant to the application. And on this item 4, we had 3 requests, one of which was withdrawn, and that leaves the request by Lieutenant Colonel Mark Shipman and by the Jonah Water Special Utility District, which is a governmental entity. And this application seeks authorization for a final phase discharge of 450 gallons per day. Mr. Shipman resides within a half a mile of the facility and raises concerns that are relevant and material to the application, so I would grant his request. Jonah Water Special Utility District makes 2 arguments for effectiveness, beginning with its interest in regionalization. However, it's the commission, this commission, that has statutory authority over regionalization. And moreover, the district identifies an interest in regionalization with respect to the supply of drinking water, that is drinking water systems, not wastewater systems. So I do not view this as an adequate basis for effectiveness. The next argument is the district asserts that its water CCN is a basis for effectiveness, but that certificate, that obligation to provide water service does not by itself create jurisdiction over an interest in water quality within that CCN's boundaries. So in my view, the operative issue is really about where Jonah Water draws its water. This is a water quality issue, not a water supply issue. So the question is, might this authorization, if it's issued, affect its water source? Jonah Water does identify Lake Granger as a source of water, but that's over 15 miles downstream from the proposed facility. And in my view, given the relatively small discharge amount and that considerable different distance, Lake Granger does not support effectiveness. The district also indicates that it relies on other sources of water in addition to Lake Granger, but it does not identify them. And so I think the bottom line is that we, although there are some allegations that might put this into issue, I think the bottom line is that we lack sufficient evidence to evaluate whether there is a personal interest on behalf of the district. So I would grant Mr. Shipman's request. I can't grant Jonah Waters' request. And I think I'll just pause there and gather your thoughts on who is entitled to a hearing.
I don't really disagree with anything you said. You know, I know some of the parties had said to refer Jonah. You know, I could get comfortable referring them for effectiveness, but I'm also fine just naming the lieutenant colonel as the only party in the hearing request and letting it go that route. And
I think I'm a little on the fence as well.
yeah, it's a
Commissioner
tough one.
Chineka.
I appreciate the input from each of you, and I think given that we refer both parties and also issues, we would surrender our chance to have any say on the issues. I think that if Jonah Water Special Utility District were found to be an affected party, there are different issues that I think their requests raised that could go forward into the SOA case. I'm comfortable. I think I'm comfortable, relatively comfortable either way. I think SOA has proven that they interpret a different set of rules to apply and are different. They interpret the same statute differently in applying to us versus them in terms of whether parties can participate or not in the contested case. And so I'm not concerned about Jonah said really making their case if they want to make this issue. Perhaps we could discuss the issues, and if we have some agreement on what two issues they raise. And very briefly, I think theirs are different than the one issue I would find with Lieutenant Colonel Mark Shipman being found affected. I think his request really clearly raises the protectiveness of the health of his family, he and his family. But I think looking at Jonah Water Special Utility District's request, I could find a basis for moving forward on whether the draft permit would be protective of water quality, preventing specifically excessive algal growth, and then whether it's regionalization, I think, was an issue that they did raise, albeit imperfectly and as a basis for their participation. But perhaps we could craft a motion or referral that SOA can consider them with issues highlighted if they're found affected.
Yeah, a contingent, sort of a contingent.
I don't know that we have that ability if
Yeah.
we deny outright their ability to participate as a party.
Yeah, I mean,
Yeah,
and
that's a fair
Commissioner
point.
Lindley, kind of all things considered, I think I'm maybe ever so slightly on the side of going ahead and referring the district to SOA for an effectiveness
Yeah.
determination.
And be
then-
specific in the issue so it doesn't,
Right.
the
So we
ability
would
doesn't
we
exist
would
for it to go a different
Refer
path,
the
but-
issues unique to the district
Mhm.
as well, but contingent on SOA's
finding them
determination
effective.
that they are affected. And if they find that they're not, if the district's other water sources are
Right.
another 15 miles away, they clearly would not be affected, and then the SOA could ignore those issues and just take up Mr. Shipman's issues.
yeah.
And just to be clear, I think I agree entirely with you that the only possible overlap that the Jonah Special Utility District here could really clearly argue is on water quality impacts. If they have some perhaps groundwater wells or something where they sort their water that really is within the vicinity of this district.
Right. So who wants to make a motion?
I can stumble through it.
Okay.
If y'all will entertain. I move that we grant the hearing request of Lieutenant Colonel Mark Shipman, refer the application to SOA for a contested case hearing on the following issue. A, whether the draft permit will be protective of the health of the requester and his family and contains sufficient provisions to prevent nuisance odors in accordance with 30 Texas Administrative Code, Section 309.13E. Further move that we refer the hearing request of Jonah Water Special Utility District to SOA to determine effectiveness by determining if it draws drinking water from surface water or wells that are on or near the discharge route and that will be impacted by the proposed discharge. If SOA finds that Jonah Water Special Utility District qualifies in this manner, then refer to SOA the following additional issues for adjudication. B, whether the draft permit will be protective of water quality, including the prevention of excessive algal growth under the applicable Texas surface water quality standards. And C, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of regionalization under Texas Water Code, sections 26.0282 and 26.081. And finally, set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I would second that motion.
Sounds good to me. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the application by Kinder Morgan Petcoke LP for a major amendment with renewal of TIPD's permit number WQ00026599000. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, colleagues, item 5. This is the last of our 5 TIPD's applications. And again, on this one, we have a single requester. And in my view, the question of whether Bayou City Waterkeeper has demonstrated effectiveness turns on whether their member, Ms. Gray, would have standing in her own right. The association has otherwise met all of the requirements to be entitled to a hearing. The arguments for Ms. Gray's standing are connected with her residence and recreation at Berry Bayou, as well as her recreation at Sims Bayou. And on this one, the proposed discharge is not large. The applicant represents that its activities will generate 40 gallons per day of wash water and 150 gallons per day of quench water, plus a variable stormwater flow. And the type and concentration of the contaminants at issue do not indicate a significant concern. Accordingly, given the distance between the outfall and Ms. Gray's residence on Berry Bayou, I can't foresee any impact there, let alone one that would distinguish Ms. Gray's interests from that of the general public. And so that leaves Ms. Gray's recreational interest at Sims Bayou. And while recreational interests can potentially demonstrate that someone is affected differently from the general public, in this case, I don't see it. We're told that Ms. Gray regularly walks along Sims Bayou near Park Place Boulevard and the Houston Botanical Garden. And given the distance from the facility to these locations, which is well over a mile, and the small rate of the discharge, I can't see that Bayou City Waterkeepers has demonstrated Ms. Gray's personal interest distinct from the general public. So that is my analysis.
I'm in agreement.
I too am in agreement. I appreciate you raising specifically that last point. I've heard it raised, the false suggestion that we don't consider recreational interests and whether parties can have standing or a basis to contest a permit. I very strongly disagree. I remember, or I've been in favor of granting hearing requests on specific recreational interests in the past, but I don't think this hearing request meets that requirement to find Bayou City Waterkeeper to be an affected person. They identified the one member that they contended would have standing in their own right for the hearing, and so given the relatively small volume of discharge and the discharge of the outfall where Ms. Gray recreates, and specifically the manner of her recreation that was described, and the potential for that relatively small discharge didn't seem to raise something different than another member of the public affected. But I think that was exactly the right direction to make that sort of a basis. So I agree. I'm ready to move forward as well.
I've got a motion.
Great.
I would move that we deny Bayou City Waterkeeper's hearing request, that we issue the renewal and major amendment of Texas Pollutant Discharge Elimination System Permit Number WQ00026590000 to Kinder Morgan Petcoke LP as recommended by the Executive Director and adopt the Executive Director's response to comments.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
Was away in Fort Worth.
That takes us to our enforcement docket, which is items 6 through 15 and 17 through 20. Item 16 was remanded to the ED on April 19th. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer and Michael Parrish of the of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 6 through 15 and 17 through 20. The total assessed administrative penalties are $608,130, with $263,461 deferred, $149,708 applied towards supplemental environmental projects, and $194,961 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No, thank you.
Likewise.
Seeing none. Ms. Smith, has anyone signed in to speak?
So for items 7, 8, and 13, we have people signed in who are available for questions. And then for item 11, Mr. Michael Burris has requested to address the commission.
Great. Mr. Burris, are you with us? Yeah, good morning, sir. If you'll just step up to the podium there. Thank you for being here. First thing we need to do is make sure your mic is turned on, so there should be a little button that says push that'll make the light go green.
Okay.
You got, all right, we hear you loud and clear. Mr. Burris, the floor is yours. We're happy to hear from you.
Well, I was just coming to see what this was all about. I know it's about a stack of tires that I have on my property.
And let me just interject here real quickly if I can. I just want to make clear for the record that you're speaking on item number 11, and then if you'll just state your name again for the record.
Michael Burris, and I'm speaking on item 11.
Okay, I'm sorry to interrupt you. Go ahead, sir.
And I just have a stack of complaints here through Guadalupe County, through TCEQ. This is not all my records. I just didn't go pull more open records because this is an ongoing battle between my neighbor. What is her problem? I have no idea. But I have been in compliant with the county. The county told me to move stuff to a certain spot out of her site, cover them up. I'm in compliant. So she trespasses on my property, her and her son, to put me in violation. So this violation is from somebody trespassing on my property to nail me with it. I've been dealing with the county for quite some years now over this, and I am in compliant with them. So they go above the county's head, above and beyond, to TCEQ. They've been out several times. That's not enough for her, so she calls TCEQ again over this past month, and they come out and investigate without me even being home. No problem. I'm supposedly running a paint and body shop now. They do an investigation. They don't find nothing. So I hope something gets put in place, like a $10,000 fine for a complaining neighbor that just complains to complain. if they make it a steep enough fine and they don't find nothing, then they're gonna get hit with the $10,000 fine. They might think twice about calling on the neighbor.
And Mr. Burris, what is happening on the property out there? This is a property that's connected with your residence?
She
Or
has a
separate.
very little spot.
Okay,
I have 5 acres. I have tires down on my property. Yes, it's in the floodway. They have been in the floodway since I bought the property. So,
the tires came with the property, you're saying?
most of them, yes.
Okay,
Somebody was cleaning the next door neighbor property up before they sold, and I found when I went down to the bottom of the property, because I don't go down there very often because I've been rear-ended, I'm looking at surgery on my neck, and I just got over a broken foot. And they're giving me 30 days to take care of all these tires. Can I be in compliant with that? No, I cannot.
okay. Sorry to hear about your injuries, sir. You entered into an agreed order with this agency, TCEQ?
No, yes, I did,
Okay. And what,
because what else do
Go
I
ahead.
have to do?
yeah. Okay. And what are your concerns about that order?
I really don't have no concerns. I'll pay the fine.
Okay.
Should I have to pay the fine for inheriting tires and somebody trespassing on my property to get pictures to incriminate me?
Right.
I don't agree with that.
Right.
You can't see you cannot see the tires from anybody else's property. So you have to come on my property to take the pictures. But can I go after her for trespassing? No, they won't do nothing to her.
Yeah, her, whether she trespassed and what the recourse or punishment would be for that is outside of our jurisdiction. So that's not something that we
Sure.
can consider. What we do is that when we discover, however we discover violations, we pursue to remedy those, and it is frequently through an enforcement action that results in an agreed order, a contract to settle the dispute, as we have here. And I understand your frustration, and I certainly get the gripe about having somebody come on your personal property without your permission. That would irritate me as well. But really, what's before this commission is just this agreed order, and it sounds like you're all right moving forward with what you've agreed to here, so that you can settle your business with this commission. And in terms of the trespass or other issues you have with your neighbor, those are going to have to be sorted out in a different
I
forum.
understand.
Okay.
But how can I be in compliance with the county and then they go over them and over them and over them and then boom?
Yeah, and I don't know what the county's particular rules are, but
I have paperwork right here saying I'm in compliance.
yeah, I appreciate that. I don't doubt that at all. I'm not sure how to phrase it. We suffer from a lot of government, local, state, federal, and satisfying the requirements of one doesn't necessarily satisfy the requirements of another. So when it comes to the state of Texas's business, and specifically TCEQ's business, we're just trying to bring people into compliance with our rules. We do that through enforcement actions and agreed orders like we have here. And whatever business you have with the county, it sounds like you're good with the county, that's outside of our authority to do anything about. Whatever business you have with your neighbor, we're not really in a position to do anything about that. So in terms of sort of wrapping up and closing out the obligations with the state and our agency, I think
Well, I'm still ongoing with TCEQ.
yeah, and I understand that the agreed order has a lot of requirements in it, including paying a penalty but I don't hear that you're trying to, that you're objecting to that or trying to get out from under that today. I think what I'm hearing you say, and you can correct me if I'm wrong, is that you've got these outstanding issues with your neighbor. Your neighbor shouldn't have been on your property. Again, we can't do anything about that.
I have outstanding issues when more complaints and more complaints and more complaints keep coming in. TCEQ, I just spoke to them last week about air quality control, not solid waste, air quality control.
Right.
And it's like, when does it stop?
Yeah.
When does somebody from TCEQ say, enough's enough?
Yeah, I get you. And so we do have enforcement discretion, how we look at different cases. We've got some discretion and flexibility, but when it comes to responding to complaints, we have there's a whole set of laws and a protocol that we have to follow, and our investigators don't have a whole lot of discretion. They can't just simply ignore the complaint. That would that would be out of bounds for our investigators. But
If you have 20 complaints for the same address,
yeah,
that they can't say, no, we can't? I mean,
it's and I think we're starting to maybe stray a little bit off topic of this particular enforcement order, but just to try to finish out and round out the conversation, this is a very hot topic because we have there are complainants out there that use our process to harass others, plain and simple. That happens. It's somewhat infrequent. Sounds like it is happening, unfortunately, in your case, perhaps. That's what I'm hearing. I know that the legislature has looked at this, is looking at it right now. I guess what I'm telling you in terms of how the agency responds to those complaints, we have just kind of very limited discretion in how we approach those complaints. We are not allowed to simply ignore complaints because somebody complained multiple times, even if we recognize them as a nuisance complainant. Now, I'm trying to offer you a constructive solution to your problem, and so I'll just say what I'm thinking. Historically, and under very rare circumstances, we will have our Office of Compliance and Enforcement assign a particular point of contact in senior management to be the person who receives complaints relating from a particular complainant. That's just a historical fact. Whether it would be appropriate to do that in this case or not is an open question in my mind. So I think what I would invite you to do is to talk with somebody in management, with our Office of Compliance and Enforcement, and have a conversation about whether they would be willing to assign a single point of contact for the complaint process, just so we can have a better sense of what's going on in your situation, and hopefully discourage complaints that are without merit. And another thing I might suggest, in the spirit of being constructive, is share your concerns with your elected representatives. And I should probably just leave it at that. Mr. Burris, I'm not hearing complaints on this agreed order. I'm understanding and hearing your complaints. I'm probably over-responding to them, but that's my constructive advice for you this morning. And I really appreciate you showing up today and sharing your concerns. But in terms of what this commission needs to do this morning, I think that's just to go ahead and finalize this agreed order, and it sounds like there's no objection to to that piece of it. Does that sound all right?
Sure.
Okay. Well, thanks again for coming down today. Colleagues, do you have any questions or comments for Mr. Burris?
I have a question about 30 days. That's what I,
The order in this, in the terms of the agreed order to be able to meet those terms in 30 days. So, Mr. Burris, I'm hearing, and I appreciate, Chairman, you're laying out and diving into the issue so specifically on his concerns. I want to ask him simply, since I don't have the benefit of a legal degree and a member of the state bar. I'm not an attorney. I know, I presume you are you an attorney,
No.
Mr. Burris? Good. We're on equal footing in that regard. So if I'm hearing concerns about potentially what we have before, we have an agreed order that you've told us you're in agreement with, but I'm hearing some concerns that if you're wanting to plead your case around it, specifically the practicability of being able to comply in the 30 days, when that sets in, but also whether the violations are even on you or not, if there's evidence you might be able to bring that there's somebody else. But this penalty before us dates back to a complaint that was in 2021. And so there's a certain set of dates, and it's closed, and it's in the past. And so there may be some limits to, you found new information after that point in time, and so maybe you've decided it's not worth trying to argue this particular case. It sounds like it is an open issue, though. If you've had any back and forth in the last month, I can guarantee nothing of that back and forth would yet show up in this particular order. So in order for me to understand our place forward, I think we could entertain that maybe you are not in agreement with this agreed order and you instead would like to take the alternate pathway to plead your case on this order, which means you would go follow the order to SOA, the State Office of Administrative Hearings, where you would come before a judge who's an attorney, but they do it full time, and so hopefully they can help walk you through the process. But that's where you could bring evidence or make arguments of whether it's perhaps an inappropriate
the problem
stuck
with
penalty.
that is I'm just a poor
I respect
guy.
that. I respect that.
I
And as
only
much as
have
that's
6
available
days.
online now and it's easier to do, it's still very difficult, and that's a big hill to overcome. But as I understand it, I think that's where we can offer you a path forward and a remedy to close out this penalty that dates to a certain date certain from that complaint and investigation from our staff, doesn't handle any of the ongoing future stuff, or you could keep it open and continue to fight it at this other administrative court. And I just want to confirm, is that your understanding of the process as well? And do you have any questions about that?
From my understanding, if I don't agree to this order, then it's going to be a steeper order. That's from my understanding.
I appreciate that.
So why not just take it and make the payments and pay that little bit what I can?
I'll
respect
just
that.
chime in real quick. I do want to hear from the executive director's office here in a minute on this. I'm glad we've heard from you. Appreciate you coming down up here. I think we need to hear from them. I think the best thing you can do for yourself, and I'm not saying you haven't already done this, it sounds like maybe you're there, but, I don't know, is stay in compliance, right? And that's the best way to prevent anything. If you're going to have a nuisance complainer, we'll characterize them that way, even though I don't really know anything about them. Call and complain. By law, we got to get out there and investigate. That's just the way law is written now. If we go there and we don't find anything, that's going to go a long way. And so the best thing you can do moving forward, and again, I'm not saying you haven't, it sounds like if the county's been out, you're abiding by their laws and that kind of thing, and that's great. Just make sure you're abiding by ours, because then there's nothing to document as being out of compliance. And a person's complaints, you can only cry wolf so many times. And while we are obligated to go inspect everything we get a complaint for, anonymous or not, that eventually can be a factor. And I'll just kind of leave it at that. So I think it is your decision at the end of the day if you do want to continue forward with this agreed order, or it's your decision to say, I don't agree with this order, what's in front of us today, and I do want to go a separate route, which is to kind of like it is a trial. You could handle that however you wanted, whether it was yourself doing it, you hire an attorney, that's your discretion, and it would come back before us, and ultimately we would decide on it again. So that's kind of your two options, which is what Commissioner Janetka was referring to with SOA. And it sounds like you do want to agree with the order, and I can't advise you what to do, but That's what's in front of us today. Those are your two options. I don't necessarily have any more questions for you. I really do appreciate you coming up and telling your side. I think we need to hear from the executive director and then decide what we want to do. And we can, I plan on asking them just so they know what kind of negotiation, if any, can be done on extending the 30 days or that kind of thing. So unless y'all have more questions, I'd say you can sit and we'll now ask our questions of them and then we'll figure out how to move forward. If you're finished, and I don't want to cut them
Actually,
short.
Mr. Burris, I'm sorry, I do have
Oh,
one question for
I
you
spoke too soon.
before I ask the executive director to respond. But setting aside how much time it takes you, what are your plans for removing those tires? How are you going to do that, and what are your,
Well, I've already had one dumpster down there, a roll-off, and it's only me, so I only have 3 months with a dumpster. And I have to take a razor blade knife and sidewall every tire and process it. They give me two options, sidewall them and then the tread, or I can quarter the whole tire and put it in the dumpster. So TCEQ wants me to have documentation of where I'm taking these tires. Well, I don't own the dumpster. I don't take the dumpster to the landfill. There is a certified landfill in San Antonio that will accept the tires, and I've already explained that to them. And they're like, well, I don't know if that's all right. I'll have to get back with you. So there's no difference between the roll-off dumpster and the regular dumpster. So instead of only getting 3 months, I was just getting the regular dumpster, putting my trash as well as processed tires in that dumpster.
okay.
Am I throwing them in neighbors' yards? No, I'm
Right.
cutting them up.
Right, okay. We may have more questions for you, but I think it's time for us to hear from the executive director on this item. And colleagues, I don't know if you had specific questions, but
Well, I kind of asked my one if,
Yeah.
you know, and I don't know who's best to answer that, whether it's Gitanjali or whoever.
Good morning, Melissa Cordell, Enforcement Division. In regards to the order itself and the timeframes for compliance, there is a provision in the agreed order that allows for them to get an extension on those timeframes for cleanup. So we review a written request that basically indicates that they've made some good faith efforts toward coming into compliance with the order, what's required by the order. So we need to know that they've ceased accepting additional tires or any other MSW, as well as making efforts to properly dispose of the tires that are currently there. I believe that covered that question. So
Is an
just-
extension 30 days, or is it just depends on how far along cleanup is
Depends on the
going?
request.
Okay.
And that there's a good faith effort
Yeah.
to try and do that. So if we could get a commitment that no additional tires and that they were working to properly dispose of them, using a registered scrap tire transporter and making sure that it's all proper. We can provide a list as well of what those registered scrap tire transporters are to assist.
I kind of just want to hear the background on the case. I don't know. What's in front of us in the agreed order?
can I ask a quick clarifying question? The registered scrap tire transporters, do they require removing sidewalls or quartering tires, or will they take an intact tire, if you know? Mr. Burris probably knows.
Well, will they take the dumpster roll-off too, or do they have to take and process the tires?
I need to seek additional information on that, and our San Antonio Regional Office is also on the line, and they may be able to assist us with part of that question.
Is there anybody?
Good
from-
morning.
Yeah, good morning.
This is George Ortiz with the regional office.
Go ahead, Mr. Ortiz. Did you hear the question?
Can you repeat the question, please, sir?
Yeah, the question is whether the scrap tire haulers require sidewalling or quartering the tires before disposal.
It depends on the facility where the tires are going to, landfills. Some landfills require sidewall or quartering. So
Okay.
depending on who they use.
Okay, I understand. I think, and we can ask him in a minute, but I think Mr. Burris is going to tell us that yes, indeed, he is required to do that. I'm sorry, Commissioner Lindley, you had another question for
I was just kind of
staff.
looking for a little bit of more background on the, what's in the agreed order, you know, the steps, communications that were had and that kind of stuff getting here today.
Okay, so the investigation was conducted in May 6, 2022, based off of a complaint. We were in communication with Mr. Burris back in June of 2022. We mailed out a draft agreed order September 16th, 2022, and had follow-up communications with him to ensure that he received the order and understood the terms of that order. We followed up again in regards to settlement, discussing payment plans, as well as the financial inability to pay. And that was in October 2022. And then in this follow-up as well, we had in January 2023 discussed additional things such as the payment plan that's included in the order. And then we reached a settlement. December 2022, thank you. And from there, we've just communicated that agenda was coming.
Okay, and
Thanks.
I have a question about sort of proof of proper disposal. Mr. Burris had raised some concern about not knowing where the tires would ultimately be disposed of, just that he was handing them over, surrendering them to an authorized transporter. Is a receipt from an authorized transporter enough, or can you or maybe Mr. Ortiz shed any more light on that particular requirement?
We would need documentation, and I don't believe that we've received that documentation those actual receipts, and if we have, then we'll verify that. For that next step, my understanding in talking to our waste permits folks is that we would need something to show where they went ultimately, and then we can verify what their authorization is.
Okay. And I don't know how that's typically handled. So, Mr. Ortiz, let me ask you that. Do you happen to know how that's handled on these scrap tire cases?
We can
And
work with the.
by that, just
the,
let me be clear about what I'm
respondent.
asking. You know, exactly what documentation would Mr. Burris need to provide the commission to satisfy the order? And how does he get that if he doesn't know where they're going? The transporter, I guess, knows where they're going.
Correct. The best thing for him to do is get copies of the receipts from the transporter and the location of the disposal of the tires. That would work for us.
Okay.
Do transporters usually provide that? Do they usually say, we're taking this to the whatever county landfill? Because that's what we need, right?
Yeah.
A manifest or something
Yeah,
like that.
thank you, yeah.
Receipt or manifest.
Yes, sir. That is what we were asked. The transporter will provide that information at requested time.
Okay, so the authorized transporters are required to provide documentation, whether it's receipts or manifests or whatever you want to call them, that would satisfy the agreed order.
Correct.
So if the transporter is refusing to provide that kind of information, you might assume that they're not an authorized transporter. Okay.
There may be an issue there. Correct.
Yeah, okay. All right, I've got a couple more questions for Mr. Burris, sir. Okay, I think we're down to two issues, maybe. One is you can't get this done in 30 days. The other is you're concerned about getting the appropriate proof from the transporter that meets the requirements of the agreed order. Does that sound right?
I sent one receipt for the roll-off dumpster, and it was through Apache Dumpster Service. I'm assuming that wasn't sufficient enough. They don't say, we hold tires. They don't put that on the receipt.
Mhm.
They put a receipt for a dumpster.
Right.
So the rock and the hard place appears to me the proposed under technical requirement in this proposed order within 30 days of the effective order, remove all MSW, municipal solid waste, including scrap tires, from the site and dispose of it at an authorized facility. And on that very small phrase, because I can't find any other references in this draft order, agreed order that reference transporter or the manner of removal, I'm worried that what you're currently doing to solve your problem is creating a bigger problem in our agency's eyes, where if you do find a authorized transporter and a facility, because right now you've only provided us a receipt for a dumpster. You've not
Correct.
provided us a receipt that we can show the public that your tires that were on your property have been disposed of properly.
Don't-
Because where you're cutting up, whatever I hear, there may be tires getting cut up and disposed of in another waste stream. If that 650 tire number shrinks through your efforts, which I appreciate is in cleaning up our environment, there may be a perverse rock and a hard place where our agency may ask, okay, well, where's your receipt at a tire disposal place for 650 tires? Or a tire shipper, who we trust them. And so my problem right now is the boogeyman of the skeptical public outside of your property looking in saying, where'd those 650 tires go? Because right now, that's where I see our draft order references the investigation and our findings, where I appreciate your nuisance neighbor complainant issue, but in our agency's eyes now, there's tires out in the environment, and in the past, we've been burned by other property owners who took care of the tire problem, and suddenly we found their neighbors had a scrap tire facility appear in their property. So it's an unfortunate circumstance where we now require that bar to be met in order to close out this agreed order. And I can appreciate where I want to make sure that our staff are able to visit with you thoroughly about where you're addressing the problem right now, and make sure that where the roll-off receipt has fallen short, if your home waste disposal, that pathway finds some pathway where someone has safely and meeting all of our regulations and requirements, taken tires and disposed of them, and if it doesn't typically meet our usual, this fits our bill, I would love us to be creative and try to stretch to make sure that our process can acknowledge the efforts he's done to safely dispose of the tires. But I appreciate the rock in a hard place, where just by virtue of the nuisance, by virtue of the public being plagued by tire piles in the past, I'm sorry that you're stuck in this hard place to see this instance, but I can understand, unfortunately, where we're at.
When I processed the tires, put them in the dumpster, I physically, myself, took pictures of the tires in the dumpster and provided the receipt. That way, I have pictures and the receipt matching, hey, they're in the dumpster, and every tire that was in the dumpster has to be processed, because when that dumpster goes to the landfill, if there's one tire, then they upcharge them astronomically. And Liberty Tire is the only recycler that I know of that transports scrap tires, and they transport them whole, but they charge you like $6 to $10 per tire. I can't afford that.
That's an important point I really want to zero in on. Our agency's estimates of the costs of scrap tire removal, I think, puts disposal at $5 per tire. And where our agency, the bean machine processes the permits and things, where we're not necessarily going to be as quick as the consumer to say, hey, my grocery bill's going up, inflation's hitting. I'm curious to see if our agency's cost estimates will reflect that, and perhaps that this is another instance of this. Our administrative process for the violations and agreed orders always functions slowly. It follows at a long delay. We have to get all the paper in order. So if that tire cost accounting is changing, it may have already done so, but unfortunately, from we're consistent to the time we've done it. So that's helpful to know. It was what rough estimate you said it was cost?
It's been a while since I've called Liberty. That's why I started
But-
processing them.
Sure.
It was anywhere from $5 to $10.
5 to 10. That's helpful. Puts our estimate in a very reasonable space, but it's one that I'm sensitive to, where
I've actually taken a load there, and they wouldn't accept it for some reason or
From you
another. I
directly?
don't remember why. And because I actually spoke to a sales guy on the phone and then took them, and then they turned me down. So I went back home, and I sat there in the driveway and cut them.
Colleagues, let me propose this.
And it's hard to pay that $6,000 fine when I have to pay $5 to $10 a tire to dispose of it.
Mr. Burris is telling us that he's ready to pay the fine. He's ready to clean up these tires. He's concerned about his ability to comply with this particular agreed order because of the timing requirements, even though there's an extension, and because there's certainly some confusion around what documentation he needs to be providing. So I think that this very, very well may be an appropriate agreed order without any changes. But, you know, I would entertain the possibility of changing it also. So what I'm going to propose is that we remand this item to the executive director, just so that that Mr. Burris, you and our staff can come to an understanding about how you're going to be able to comply with this agreed order, and then then you can get some comfort around it, and we'll go forward maybe with the same agreed order, maybe with some slight differences.
That can be, yeah.
I'm comfortable remanding. I'm curious whether Mr. Burris is interested to be quit of it, or whether a remand sounds appealing. It may feel like you're sliding back down, so I don't want to suggest, and we move along with it thinking, hey, we're giving you relief, and you feel like we've just put you back to square one, asked you to.
Fair point,
to
Mr.
start.
Burris, your option. You want more time to visit with our staff to get some clarity on how this proposed agreed order would work, and how you could not find your, execute it and not be in violation of it, or are you comfortable enough with the extension provision that you heard about and that you want to go forward today and help get it behind you? Because I think we're ready to either send it back to the executive director's staff or go ahead and enter it as a
Well,
final order.
I need to know how much time I got and, how I can get rid of them and all that.
Right.
Documentations.
Well,
I
tell
mean,
you what, why
I
don't,
can't do very many at a time. 'Cause
I think that answered my question. I think it would be helpful for you to talk with our staff and sort through those issues.
I think so as well. It
All
would
right.
relieve you of some more pressing deadlines, and I think let you keep discussing the most material issues.
All right. So I think we have a plan on this one. Mr. Burris, thanks for coming down here and again and letting us understand the world the way you view it. It's helpful for us to hear that.
Do I need to stick around here now, or?
I think we're just about done. The commission is going to vote in just a moment on all of the enforcement items, including yours. And I think what we'll do is we won't go final on yours. We'll send it back to staff, and you can talk with them about this order and just sort out those last few concerns that you have about timing and documentation. Ms.
And-
Cordell?
And we can meet with you just after this, when proceedings conclude.
And we're pretty close to the end of this
Yeah.
thing, at least they are. So if you want to hang out for just a few more minutes, you can probably have that conversation pretty quickly. So thank you, sir. And Ms. Smith, that was the only person signed in wishing to speak?
That is correct.
Okay. Mr.
I can, oh, nope, we're not ready.
We
Not
need to
ready
hear
for a
from
motion. Yeah, no,
OPEC.
no.
Yeah, Mr. Arthur, good morning.
Good morning, Chairman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ, Public Interest Counsel. With the exception of the remand of item 11, we support adoption of these enforcement orders as presented by ED staff.
Thank you. Colleagues, I do as well. I think I'm ready to move forward with the remand of item 11.
I can make a motion for that. I will only note before we move on, I appreciate on item 13, representative from the city of La Jolla being available on that. That's a matter I'm very concerned about. I hope that we can, my presumption is that often our agency's compliance process serves to be a valuable tool for water providers in helping move up their prioritization and how urgently they get funds from water development, the Texas Water Development Board, or other assistance available to utilities. So while I know that our staff are always available to assist utilities facing variety of challenges, in addition to those very specific technical challenges we're raising in this order, I'll just say thank you to the representatives from the city, and please do continue to reach out to us as we can hopefully support your argument for it's a statewide search for resources to apply to our water needs, and this exemplifies that need, unfortunately.
Thank you, Commissioner. Do we have a motion?
I move that we remand item 11 to the executive director for additional case development, retaining the discretion to retain the penalty deferral, and adopt items 6 through 10, 12 through 15, and 17 through 20 as recommended today by the executive director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Mr. Burris, this crew has one more item that we're going to call right now, and it won't take very long, so hang tight. Ms. Smith, go ahead and call item 21, please.
Item 21 is the consideration of the monthly enforcement report, and the executive director's staff is here to present the matter.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Amy Sedemeyer and Michael Parrish of the Enforcement Division, and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2023 through February. There were 513 effective administrative orders issued, and of those, 70 contained supplemental environmental projects. These orders assessed a total of $6,626,015 in penalties, with a payable amount of $4,007,877. $1,810,067 are to be paid towards supplemental environmental projects. 6,730 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,051 enforcement action referrals have been received. There were 2,217 pending administrative orders, with 919 cases that are on the backlog. 188 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 2,225 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No, thank you.
Seeing none, Ms. Smith, is anybody signed in to speak?
No one is signed in.
Okay, Mr. Arthur.
OPIC appreciates the report, and I have no comment.
Thank you. I appreciate the report as well. There's no action necessary on this item, so Ms. Smith, I'll ask you to please call the next items.
Items 22 through 25 are for closed session. The commission will meet in closed session today in Building E, Room 211S at, should we say 10:40? At 10:40, as permitted by the Open Meetings Act, to take up, including Texas Government Code Section 551.071 and 551.074, to take up and consider matters pursuant to items number 22 through 25 as posted and noticed.
The time is 10:37, and we are in recess.
Muted.
The commission met in Building E, Room 211S for closed session from 10:40 a.m. until 11:22 a.m. on item numbers 22 through 25 as posted and noticed pursuant to Texas Government Code Section 551.074. No action was taken. The agenda stands adjourned, and the time is 11:26.